Welcome back. We continue with our focus of what happened at the International Court of Justice today. South Africa making a presentation as far as its case of genocidal intent against Israel over alleged war crimes committed in Gaza and the suffering of Palestinians. Today, what is being sought as an immediate remedy is basically an order for a ceasefire, if you will, for Israel to stop attacking Gaza by land, sea and air. Let's speak now to the University of Johannesburg's international law professor, Hennie Strydom. A very good evening to you, Professor Strydom. Good to have your time. Let me get your assessment then of the strength of the South African case as it was officially laid out today.
Yeah, I think in general it was a well-prepared presentation orally by all the members of the legal team, and it was very logically structured to bring the court into the whole thing about what is required by the Genocide Convention, and that is what the team focused on. And I think that was a very good strategy to stay within the confines of the Genocide Convention. The division of labor between the members of the team, I think, was very good because it sort of it allowed the court to understand the logical unfolding of this whole drama, the consequences thereof, and each and every one of the allegations made by the team, the submissions they made, was substantiated extensively with facts. And then eventually, in the last sort of presentation by Professor Vaughan Lowe, he pulled together the whole presentation by the different members of the legal team. And that was an excellent summary of what South Africa wants from the court and how South Africa has substantiated its claims and on the basis of which the court will have to decide. After, of course, Israel has presented its case.
And what about the question then of proving genocidal intent? Because, for example, I just want to take a line from South Africa's papers where they speak of how basically they say Israel's actions include killing Palestinians in Gaza, causing them serious bodily and mental harm, as well as inflicting on them conditions of life calculated to bring about their physical destruction. Was that proven in that methodical laying out of the case today?
Yeah, I think the evidence provided by South Africa was substantial. We must remember that the court is now not deciding on the merits of the case. That's a totally different story and a different standard of proof. It's a lower threshold that South Africa has to cross when asking for interim measures. All that South Africa has to prove is that at least some of the allegations made and some of the facts provided will allow the court to say that these events that have unfolded over time are capable of falling within the confines of the Genocide Convention without bringing out a decisive decision on whether Israel has committed, in fact, a genocide under the Genocide Convention. I think they have.
As you say, Professor Strydom, today is basically these 2 days about dealing with the immediate relief, basically primarily trying to ensure that the court orders Israel to stop the ongoing war in Gaza. Also, what was touched upon was the issue of urgency, and the South African legal team was saying what proves the urgency and why they've now petitioned the court is that the bombs are still falling, children are still being orphaned at alarming numbers, pregnant women being left with no other choice but to give birth without anesthesia, health facilities destroyed, etc. Let's speak to the importance of the urgency in the argument as delivered today.
Yeah, the arguments on urgency and the facts provided, I think, made the sort of a very good case for the court to say, listen, we are here dealing with a very urgent matter. And what we also have to speak about are the sort of other cases the court has decided very recently on interim measures, also in matters that were urgent. And the legal team made a comparison between those instances and the current one, and there was sufficient evidence provided to the court to say that this is actually more urgent than several of the other cases that the court has decided, where the court has decided in favor of interim measures. So I think that part of the argument was well presented, well structured, and well substantiated, and there's no doubt that this is a matter of extreme urgency.
So how steep of a climb will it be for Israel, do you expect, tomorrow, if it wants to basically convince the court that that's the side with which the ruling should go?
Yeah, I think it has a formidable case to answer. What is difficult for us now, not being sort of in the thick of things, is we have no document like we have in the case of South Africa, a written document spelling out the arguments that Israel will put forward. So we will only know by tomorrow afternoon what evidence Israel could put on the table in order to counter the arguments South Africa has presented today. It will be interesting to see how Israel will approach the matter.
What the Israeli officials and even the Foreign Affairs spokesperson who's tweeted today have made clear, though, is that they do believe or view the action by South Africa as cover for Hamas, both legally and politically. Now, in those comments made by the Foreign Affairs spokesperson just a short time after proceedings concluded this afternoon, he went on to say that they will continue with their campaign to protect civilians in Israel, but also said that they would do that while continuing to distinguish between Hamas and civilians in Gaza. Is there clear evidence of an intent, a deliberateness with which it can be said that Israel has sought to make that distinction between the innocent and members of Hamas?
Well, unfortunately, the facts speak against that, and we have taken note of what South Africa has presented today in the court, and I think that is one of the problems that Israel will face. It will have to explain the sort of extensive destruction of infrastructure, the deprivation of water, sanitation, food, medical services, etc., on a scale that is unprecedented. And we're not even talking about the number of civilians killed. So the disproportionality that we have seen developing over time is a significant aspect of what South Africa has brought to the court today. And really, this is one of the main elements that Israel will have to explain to an extent that the court will be in a position to determine, well, it has made a sort of effort to protect the civilian population, or it has failed to do so, because that is one of the crucial issues of the Genocide Convention, a failure to prevent. And that is a point that South Africa has repeatedly made in its arguments today.
Good to have your time. Thank you so much, Professor Hennie Strydom. Thank you for your time, sir.